begin with, and as I discussed before, about 40%, 40 to 45% of all law that you study in law school is premised in one form or another on contract principles. So it's not surprising that after an introductory section to law and legal philosophy and legal history, I want to go right into contract law. So let's first of all look at contract principles generally. To be valid, a contract must contain 7 elements. And they must contain all of these elements. You cannot leave one element out or another. There must be a definite offer. This offer must be accepted by another party. The two parties must be competent, which means able to contract, able to accept contracts. So for instance, a utterly mentally incompetent person or a 5-year-old are not competent parties under the law, period. It must concern a lawful matter. So party A and party B can't agree to sell party C into slavery. That's not a lawful matter. There must be a mutuality of agreement, and we'll call that later mutual assent, the meeting of the minds. But for our purposes now, it's called mutuality of agreement. 6, there has to be consideration. And I'm not talking about love, kisses, consideration, and the like. Consideration is something for value, or something that is valued. So if Grandma and Grandpa Kettle set aside a trust fund for their firstborn male and female child to attend school, high school, or not high school, college, then that would be adequate consideration. What was the consideration for doing so? Then Grandma and Grandpa Kettle can go to their graves satisfied that at least somebody in the family will get a college education. That warm, fuzzy feeling. And the final substantive element is mutuality of obligation, meaning that the parties that are contracting must understand their duties and obligations under the contract. They just can't sign something and then later say it doesn't apply to them. Now I'm going to reiterate this throughout the semester. Society wants us to contract. Contracts are easy to simplify our lives because you're giving up something of value for something of more value. In other words, you're perfecting your life. But if you agree with another party to contract, society and its laws demand that you understand your obligations, that you follow through on your contracts, and worse yet, you do not breach the contract and then make it a legal problem. So society wants us to contract, but by doing so, we must agree to certain requirements, certain obligations. Now, procedural elements are the stages in which contracts could go through. All contracts go through stage 1 and 2. The problem is in stage 2, it might be breached and thus it results in stage 3 and 4. So what are the 4 procedural elements? Formation, putting a contract together. Execution, contracts then are of different types. Obviously, express contracts, meaning contracts you understand that are clearly manifest or in writing. So initially, I would argue that contracts do not have to be in writing to be enforceable. We'll find out later that certain contracts do. But an express contract is one that is clearly manifest, either written down or oral. And the legal obligations also manifest the express contract. A second type of contract is an implied contract. It's a form of contract that we do not understand fully until it's acted upon by the person accepting the contract. For instance, there's an offer made, but it doesn't become a contract until there's some form of acceptance. So the existence and terms are not clearly manifest, but are understood by the actions of the parties. Think about this as a magazine offering or a newspaper offering. For a limited time only, come down to Best Buy, and you could buy an all-in-one printer for the low price of $179. Well, obviously you cannot buy this printer, and it says in-store only. So you can't buy it online. You have to get in your car. You have to go down to Best Buy within a time specified, and your actions then imply the fulfillment of the contractual duty. Obviously, you have to have in your pocket $179, either cash or plastic. So that's an implied contract. Bilateral contracts are clearly mutual reciprocal promises between two parties. You have a unilateral contract, which is basically a contract that is a promise by one party that is then acted upon by another party, thus completing the contract. So I will sell my clicker, my PowerPoint clicker, to anyone who presents me $20. That's an offer. And the action that's required then is the presentment of $20. Third-party contracts obviously benefit a third party. For instance, Ma and Pa Kettle putting together monies from their own accounts into a trust fund to benefit Joe and Josephine Blow, their grandchildren. That's a third-party benefit. Now, obviously, the third party is not a contractual party to the contract. They're a beneficiary. So the only thing we need clarification on is clarity from the contract, clarity from the trust. Who is to benefit? And it might be a specific class, Joe and Josephine Blow, or it might be every grandchildren to have reached the age of 18 by 2014. Okay? So it could be a clear Joe and Josephine Blow or a class of individuals. An executory contract is one that still needs to be carried out. It's not complete. There's been a lack of performance on it. In other words, performance is still pending. It's been formed, but it hasn't been fully executed. An executed contract, obviously, is one that's been completed. It's done. End of story. Definition from American jurisprudence second. It's a contract where the inequality between the parties is so strong and manifest as to shock the conscience of a person of common sense. In other words, it's against public policy. It's a delusion. No honest or fair person would accept it, given all the evidence. Ridiculous interest rates being charged, where you're being charged 300. So what I want to do is look at the first procedural step, the formation of the contract. And the first thing we have to concern ourselves with are the parties to the contract. Now, in law, majority means that you've attained legal majority, meaning that you can fully contract with other people. Now, under common law, the age was 21. Today, the age is 18. But there's an exception. The exception is you could still contract with minorities, meaning those who have not attained legal age, 18, for three things: food, shelter, and clothing. Three things that a minor may need, may demand, and may not be provided by their parent or their guardian. So the law understands that even though you're a minor, you would still need to contract with others for food, shelter, and clothing. Now, we call this stage going from one's minority to one's majority as emancipation. And it revolves around issues of independence, self-sufficiency, state-mandated age, or court order. And that's the way you're emancipated. You either achieve the specific age that's on the books. In every state of the United States, that means 18. Or you get a court order that emancipates you from your parents or guardian. Or you get married. Now notice, marriage and emancipation are hand in hand, because if you're under the age of 18, you need to get at least one parent, if not two, and or a court to agree. The same applies to one other thing that you could do: military service. When you apply to the military, you need the agreement, if you're underage, of at least one parent. And that, in effect, not only gets you in the military, but emancipates you, in the eyes of the law, from your parents and or guardian. The second requirement of the parties is mental capacity. And this relates to the ability to understand the nature and effects of the business being transacted. As long as the court can understand that you understand what you're getting into, what your duties are, what your obligations are, what you're contracting for, you too can contract. So you cannot deny contractual power to those considered, quote unquote, mentally retarded. I hate that word. Because as long as that person, that mentally disabled person, can understand the duties and obligations that he or she is getting into, he or she can also contract. Mental capacity is reached, the assessment of it is reached when the law and or the courts recognize that you understand the duties and obligations. Now, let's look at a contractual concept known as meeting of the minds. This is a question of whether there's a simultaneous understanding of the same bargain on the same terms at the same time. In other words, it's a meeting of the minds. The offerer and the offeree, the person accepting the offer, understand what's being bargained for. There's a simultaneous understanding of the same bargain on the same terms at the same time. And at law in the United States, dollar amounts are usually considered current. Meaning, if I was to say, I will pay $20 to anyone who presents me, back it up, I will sell my clicker to anyone who will present me with $20. And you have 3 weeks in which to respond. That $20 I expect the next minute is what I should also expect the next week, 2 weeks, and 3 weeks. Because dollar amounts are considered current. You can't say, oh, inflation rate, now it's $20.10, $20.15. When the offer is made that it's $20, that offer is considered current through the period of the contractual offer. Most newspaper and catalog advertisements are not considered an offer. It is only an offer when you act upon it. Okay? And here's the caution, the infamous bait and switch. What happens here is disreputable retailers will say, for a limited time only, come on down and we'll sell you the new iPad 8. And you show up and there's no iPad 8s. They don't have enough in stock. They only had 2. And they advertised in the New York Times. But instead they'll sell you iCrap 5. which is a much cheaper version, does not have all the bells and whistles, but they do a pressure sale. In other words, they get you in the door with the offer, then they bait you with that offer, and they try to switch it up on you. So you're paying maybe $10, $20 less, but you're getting a item that's worth $300, $400 less. Bait and switch laws vary by state, but it's quite clear. You must have an amount adequate to cover the expected demand. So if you advertise in the New York Times, you better have a few tens of thousands. If you advertise in the Buffalo News, a few thousand. If you advertise in Niagara Gazette, one or two. No, I'm kidding. I'm joking. Not really. Now, the third party beneficiary is not a party to the mutual assent, but they could nonetheless force the courts to enforce the contract. Say Joe and Josephine Blow, they die. Or what was it? No, it was Mom and Pa Kettle. They die. Joe and Josephine Blow reaches college age, and all of a sudden they can't find the money that was set aside in trust. They can go to the court and petition that the contract was completed when Mom and Pa Kettle put the money in trust. And they could force the courts to force who's ever holding the funds to give the funds over to Joe and Josephine Blow. All right. What I want to talk about now is the parole evidence rule. Parole. Remember, common law came from a fusion of many different types of law, including Norman law. Parole in French means words. The words evidence rule. We understand the parole evidence rule to be the four corners of the rule. Four corners of the contract. Here it is in a nutshell. If a contract is written, the parole evidence rule comes into effect. What it basically says that if there's a dispute concerning the interpretation of the contract itself is the dominant evidence. They will look to the four corners, top left, top right, bottom left, bottom right, and everything on that printed page or pages. Officially, it says prior or contemporaneous written or oral contracts between the parties are extinguished. A fancy way of saying if there were pre-contract negotiations, all of those are rendered null and void once the final contract is signed. That's the reason why caveat emptor, buyer beware. If you're going to sign something, make sure you read it, because all your prior understandings and negotiations go away, okay? And only in the most extraordinary circumstances will the courts reopen those prior negotiations. What the parole evidence rule does is it eliminates the possibility of what's called the battle of forms. The final contract is the major actor here. All the prior negotiations, phone calls, text messages, little notes when you were negotiating on Starbucks napkins, all of that goes to the wayside. All of that is thrown out in most cases because the final contract is the major piece. Okay? And only under extraordinary circumstances will the court come back into a contract and reopen a discussion of prior negotiations and the like. Now, remember that lie I told you, that all contracts do not have to be in writing to be enforceable. Well, that's what it was. It was a lie. Because in the commercial world, we have a set of rules called the Statute of Frauds. And this is all from the Uniform Commercial Code. So those of you who want to get into business law, contract law, do business, whatever, you're going to become one with the Statute of Frauds and the Uniform Commercial Code. Basically, it lays out types of contracts that must be in writing to be enforceable. You cannot have oral contracts in these areas that I'm about to get into. First, contracts affecting the interest in land. If you're going to sell a piece of land, it has to have a deed. The deed has to be registered with the county court or the town court or whatever. It has to be in writing. Any sale for real property, okay, must be in writing. And also liens on property must be in writing. Just like the lien on the car, you could place a lien on land, meaning they can't sell it, move it. I don't know how you move land. They can't sell it, destroy parts of it, improve it, whatever, without paying off the debts on it. And that's the lien on the land. That's the control item. What else is a contract? Marriage, prenuptial agreements, and contracts concerning marriage. They have to be in writing to be enforceable. The obvious exception is the common law marriage. And we're going to talk about all of this later when we look at family law later in the semester. But for our purposes, a standard marriage, not a common law one, must be in writing to be enforceable. Contracts that cannot be completed within a year must be in writing to be enforceable. This typically applies to construction contracts. Construction contracts, not always, but they tend to take more than a year to be completed. And construction contracts usually rely on subcontractors. So you have contracts within a contract. Any contract concerning surety or the role of an executor. Surety is trust. So trust funds, any type of guardianship must be in writing. The role of an executor is the guardian of a dead person, the dead person's interests. That's an executor of a will. They must be in writing to be enforceable. And finally, the UCC comes out and says any sale of goods valued at, and the current standard is $500. Anything above $500 is considered a consumer durable. That's what they call it in the business world, okay, in economics. It's a consumer durable. So normally when you buy such a thing, you don't just get the receipt. You normally get a long detailed warranty and the like. You get a contractual writing, okay? If you buy a lollipop, you don't, it's not valued, well, it must be one hell of a lollipop if it's $500. But you don't need the additional contractual duties. The UCC says if you're buying a consumer durable, a refrigerator, a stove, okay, how can we affect the formation of the contract? How can we get in there and affect the formation of a contract? Well, there's two general classifications. The first is prevention of full knowledge. You go into a contractual negotiation and somehow you're prevented of full knowledge of what you're contracting for. Like mistake. You made a mistake. Is that good enough? No. Mistake of law is no defense. Just like something else we're going to get to in a moment, ignorance. If you made a mistake and it was of your own doing, it will not void the contract. caveat emptor, buyer beware, do not make mistakes. Read it over, make sure you understand everything. Only when both parties make a mistake in a similar understanding, then the court will come in and say, redraft the contract. Because if it's a mutual mistake on the same issue, then you have no meeting of the minds. You have no mutual assent. Thus, the contract has to be rewritten. So it affects the meeting of the minds, mutual mistake. It affects mutual assent. Now, what about fraud and misrepresentation? What happens if you're prevented full knowledge by the other party? The other party's defrauding you or misrepresenting the truth of the contract or the item. Typically what happens here is the court will come in and punish the wrongdoer, punish the fraudulent party. And we have another word for that. The fraudulent party, the misrepresenting party, does not come to the contractual bargain with clean hands. That's the term that's used. He does or she does not come to the bargain with clean hands. The court will come in and totally destroy the contract unless the wronged party, the party that's been defrauded, could actually benefit from the defrauded contract. And in that case, there'll probably be a penalty against the defrauding party anyway, and the contract will be continued. Notice, the court is interested in defending the party that's been defrauded, not the party that uses fraud and misrepresentation. And finally, ignorance. One or both of the parties is ignorant to understand the terms of the contract. It's their problem. Ignorance of the law is no defense. We've already talked about this before. So, it's no defense to legal obligation. If you were dumb enough to enter into a contract and not read it and just sign it, then you'll have to be dumb enough to follow what is said in the contract. Okay? Does society want us to contract? The answer is yes. What does society want us to do? If we want the contract, we have to follow certain rules, certain standards. Now, the second general category, besides prevention of full knowledge, is prevention of full agreement. The first of these is quite easy to understand. Duress. Sign the contract or I will splatter the contract with your brains. That's the use or threat of use of physical force. Holding the gun to your head. Obviously, we want people to contract, but we want them to contract voluntarily. We don't want them to be forced, like the shotgun wedding. We do not want them to be forced into contracting. And that's duress. Now, in the business world, we have a special type of business duress. This is when one business uses another business's a bad economic situation or imminent threat of financial ruin, and they come in like a white knight to save them. They're using a form of business duress, and that's looked down upon by the courts as well, because that outfit might not have wanted to negotiate, but are felt forced to stem off financial wreck and ruin. I'm not saying which company did this typically and for decades, Microsoft, but you notice that many of the things that Microsoft has used to be other companies' property, other companies' inventions, like what I'm doing right now. This is Microsoft PowerPoint. I'm doing an oral recording that used to be done by different companies. What Microsoft does, or has done, is they would put out a cheap version of whatever, like voice recognition, or like Nuance, what do they call that? Dragon Naturally Speaking, things like that. A cheap version, which does what? In the business world, it causes competition with the better product. produced by somebody else. It forces that better product to reduce their price until such time as they're not really getting the revenue anymore and they fear closing down. At that point, Microsoft comes in and buys them out. Buys up their stocks or just literally buys them out. That's business duress. The issue is, was, and will always be one of voluntariness. If you're going to agree to a contract, it should be of your own free will, not because duress, the threat or use of force, a physical force or business force, is being used against you. Now, undue influence. This is a psychological pressure. This is you see with seniors and how they're treated. You know, all those calls they get. I mean, my father gets 6 calls a day from unscrupulous individuals who are trying to sell him things and use the fact that he's of advanced age and crappy hearing to try to force him to agree to things. My father now has a policy. If you can't identify yourself within 15 seconds or less to his satisfaction, he's going to hang up on you. My father's hung up on me several times. He couldn't identify my voice. But it's using psychological pressure, abusing a relationship of trust. I had a call last summer, and the gentleman on the phone was clearly from either India or Pakistan. And he said, "Mr. Baxter, is this Mr. Kenneth Baxter, my father?" I said, "Yes." He says, "Oh, your auto insurance is up, and we'll have to rewrite the policy." My father's had the same auto policy since 1945, right? This was not the lady from Walden, New York. This was some phone scam, right? So with my father in earshot, I said to him, "Is it on the Lamborghini or on the Porsche?" Right? And my he's looking outside, and all he sees is beat up Toyotas and beat up Hondas, right? And the gentleman said, "Oh, it's on the Porsche." And I said, "Well, the Attorney General's office of our state would be interested in your company." "What's your company's name?" Because now, void and voidable contracts. This is where law becomes existence and non-existence. Okay? So have fun with it. A void contract means that there's some flaw in the formation of the contract that results in a situation in which no valid contract exists. Unconscionable contracts are like this. Contracts which are against public policy are like this. Think of the bigamous marriage contract. You're not allowed to be contracted in happy wedlock or unhappy wedlock, for that matter, with more than one person. End of story. It doesn't matter that the second wife or husband you love more. It doesn't matter if you call them sister wives, like that one show. This is against public policy. The second marital contract is void, as if it never existed. Hear what I'm saying here? It's void, as if it never existed. No valid contract ever existed. So then what's voidable? It's when a contract can otherwise be valid, but does not bind one of the parties. For instance, competency. If you bargain with someone who is by law incompetent, for instance, you bargained to sell a car to a 15-year-old. You enter into the agreement, he makes or she makes all the payments, and the contract is completed. That contract legally is voidable, but both parties did what they were supposed to do. The young party made all the payments. The older party, for our purposes, delivered the car upon all the payments being paid. Contract's done. But there is a possibility of it being invalid after the fact. Once a contract is completed, no, the court will typically not reopen this. But any contract that was induced through fraud is voidable, meaning the court will come in and the wrongdoing party will be penalized. For instance, say you went to West Virginia and lo and behold, you're 18, you meet a pretty little thing, male or female, who happens to be 14, but the person's daddy wants you to be married, and a shotgun's put to your head, and you get married. Well, the minute you can get out of that shotgun's range, or get out of West Virginia, you might want to go to the court, because that marriage contract is voidable. You were forced into the contract by threat, duress. It was induced through a form of fraud. The fraud was that both parties wanted to get married of their own free will. Understand? So that's a voidable contract. Void contracts, they never existed. They're struck down as null and void. Voidable contracts is a contract that could exist and will exist, except for the fact that the courts will come in and penalize the wrongdoing party. Now, let me change the facts a little bit. You go through such a wedding, right? You raise children, they're all college graduates, one's a doctor, one's a lawyer, another one is, I don't know, an accountant. You're happy, they're happy, your grandchildren happy, you've got a beautiful house. 40 years later, the courts are not going to come in and void that contract. They're not going to do it. Even though it might have started out incorrectly, the marital contract worked. Both parties are happy to be married to the other party. They love their children, they love their grandchildren. There's been no other force exerted in Now, after the formation of a contract, we then have performance of the contract. At times, all the parts of a contract may not need to be followed to the letter. At times, partial or substantial performance will suffice. As long as the incompleteness of the performance is not a material breach, and both parties agree, then both parties ultimately are relieved of the contractual duty. For instance, I wanted you to lay an entire brick foundation, or cement brick foundation, before the frost hit, and you live in Buffalo. Well, you got 3/4 of it done, and you came to agreement that once the frost is done, in feels like June or July now, then you'll complete the last quarter of the foundation. The original contract said you had until the frost came, but both parties agree that's impossible. We had an early frost, yada, yada, yada. So that's a partial performance or an incomplete performance, right? At that point, the party that's been wronged, the one with 3/4 of a basement, might agree to pay 3/4 of the payments and be done with that person. They have that right to do so. Or they might say, yeah, that's fine. We're not moving in until the next fall. But you got to get the last quarter of the basement done before July 1st. Okay? Okay, it'll be done. There's no material breach. But at times, you might have to breach a contract. These are called affirmative defenses to contract action. We're going to come back to the concept of an affirmative defense. Let's move into criminal law just for a moment to clarify this. A regular defense is it wasn't me. Who shot that man? It wasn't me. I wasn't there. I was in Tahiti. An affirmative defense would be, yes, I shot him because I needed to shoot him. He was about to shoot me. See, self-defense is an affirmative defense. You're not saying, no, it wasn't me. You're saying it was me, and I had a damn good reason, an affirmative reason. Now let's bring it back to contract law. What are some of the affirmative defenses? First of all, failure of payment, failure of consideration. Say, go back to the foundation. I was supposed to get monthly, every quarter of the contract, I was supposed to get payment for that quarter. I never got paid for the first quarter of the basement, the second quarter, the third quarter. The person said, well, you failed the contract because you didn't build the rest of it before the frost came. And you could say, you can go to hell because you never paid me for any of it. That's failure of consideration. A second affirmative defense is breach of warranty. You said that this car would have flames on the side and be super fast. Well, when you bought the car and drove it, the flames weren't on the side of the car, they were coming out of the engine. Right? You bought yourself a flaming lemon. That's breach of warranty. Okay? Will you stop making payments? You have the right to. This is affirmative defense. You better, make sure you make note of all of this and consult an attorney. But that's it. You're done. You got yourself a lemon. You can even demand your money back under the lemon law. Okay? A third is an old concept called usury. This is the charging of exorbitant and unconscionable rates of interest. I like to use the example that Shakespeare gave to us. The Merchant of Venice. What was the payment on the loan? The pound of flesh closest to the heart. That's an exorbitant rate of interest. If you take the pound of flesh close to the heart, you're killing the person. Right? So unconscionable rates of interest. Exorbitant rates of interest. Okay? And the final I want to talk about is impossibility of performance. This is something hopefully you males never have a problem with, and this is when blue pills don't work. Say you contract with a famous artist, and they get 3 quarters done with their mural, and they drop dead. You cannot sue for you could sue for a different contract price with that person's estate. Here's the weird thing. You might end up paying 3/4 of the price of the mural, or you might consider the contract done. Because of the impossibility of performance of the person's death, this artwork is actually more valuable because it was the last work, right? Look at various famous composers. The Last Concerto, the Last Symphony, it has much more value than everything else. Now, you perform the contract, you complete it, end of story. You perform the contract, something happens, you have an affirmative defense, the contract might be. What are the remedies for breach of contract? Well, the most common remedy is assessment of monetary damages, otherwise known as compensatory damages. The simple fact is this. Courts like dollars and cents. It makes sense to them. So do they want you to contract? Yes. Better you contract for items specific and valued. Because, say I was supposed to deliver 10 decorated Easter eggs. And I got really, really busy and I only delivered 5. Well, the common remedy would be then you end up only having to pay half of the contract price. Understand? But say you keep doing this. If you keep doing this, You're a fancy egg artist. I don't know what that would, like Easter egg galore. Okay? But you keep screwing up your orders. The court might step in and say, hey, you're an habitual wrongdoer. And beyond just an assessment of the contract price, they might come in with punitive damages. The second remedy for breach of contract. The most common one is assessment of monetary damages. Less common are punitive damages. This is assessed by the court when it is deemed that the wrongdoer will reap tremendous additional benefits, and that they've done this countless times, and that they're in the marketplace doing it time and time again. Do we want people to contract? Answer, yes. Do they have to follow rules? Yes. What happens if they habitually don't follow the rules? Well, the courts will come in and punish them. And when it comes to large corporations, corporations factor into the price of anything the price of being found liable. So merely going back to compensatory damages does not hurt that company, so they can go out and do it again. Punitive damages are not on your $10,000, $100,000 scale. It's on your $10 million, $500 million scale. It's a hit to the company's bottom line to make sure that they don't do it again. The famous case here is the Ford Pinto. And if you have a chance and you don't know about the Ford Pinto, P-I-N-T-O, go do a Google search when this lecture series is over and look up Ford Pinto. And you'll be surprised how downright dirty the Ford company was. And the new president, Lee Iacocca of Chrysler, for ratting him out because he used to be a vice president. But read up a little bit. You'll see why courts at times need punitive damages. The final kind of remedy is one that we touched upon before, promissory estoppel. This is where one of the parties, the aggrieved party, can show that they've built up dependency on the contract. Thus, if the other party reneges, backs out, the party that can prove reliance on the contract could sue the other party in the court of law for completion. Do courts like to do promissory estoppel? No, because it's hard to ascertain dependence. Do they like to do punitive damages? Well, yeah, at times when you got a real wrongdoer. What do courts like to do? Common remedy is assessment of monetary damages. This is like if you were children in the 1930s, 40s, you got a fight with your friend, you had your marbles, everybody had a bag of marbles, divide the marbles, go home, right? Get away from each other. And in many contracts where it's contracts between strangers, that's a good remedy. Assess the damage to each party, pay it one way or the other, and move away from each other. Obviously, this is not the case when you have habitual wrongdoers like corporations, or you've got children involved in marriage contracts. Mommy and daddy don't love each other anymore. Okay, get a divorce for breach of the marital contract. But you might still have kids. You might have common property. You can't simply walk away from each other. So courts, besides assessment of monetary damages and division of proceeds or division of property, might also have mediation, ongoing inquiries into the care of children and the like. Okay? So those are your typical remedies for breach. The most common, the common remedy, assessment of monetary damages, also known as compensatory damages. Much less common, punitive damages, and almost never promissory estoppel, but it's still there. The court can still do it. Okay? I hope this helps, and please review the audio lecture PowerPoint a few times, because obviously, like I said, this is an incredibly important area of law. And we will come back to these principles. Contracts is not only just contracts. We already ran into family law in this lecture. We also ran into property law in this lecture, and many other forms of law have contract aspects to them.